Good morning. In the previous lecture, we have seen the topic of consent, and in today's lecture, we are going to continue the topic. We have seen section 25, 26 and 27 in the previous lecture. Now we are going to see the further section till 30, that is 28, 29 and 30. What section 28 states that consent, which is mentioned in all these sections, is not a consent if it is being given under fear of injury, if it is being given under misconception of fact, if it is being given by an unsound mind person, or if it is being given by an intoxicated person. Because of intoxication or unsoundness, what is going to happen? The concerned person will not know the nature of the act, whether it is right or contrary to law, isn't it? Whether it is rightful or wrongful. So he will not come to know for what he is giving the consent. Therefore, it is not a consent, and a consent which has been given under 12 years of age. Means section 28 is just a definition of consent, and this consent is not defined as consent means this. It is defined as consent is no consent if it is affected by these things. Means consent to be free, it should not be affected by fear of injury, fear of, or you can say fear of injury, fear of hurt and all. Next is fear, under misconception of fact, means the person is not understanding for what he is giving the consent. Next is intoxication or unsound mind, because of which he is unable to understand the nature, the consequences for which he is giving the consent. And the last is if the consent has been given under 12 years of age. So 28 is just the definition of consent. Got it? Now section 29. What section 29 is stating? Exclusion of acts which are offences independently of the harm caused. Means here the harm may be caused with the consent of the person, but the consent is not going to justify the harm. Means the person cannot say that, okay, I have done this harm, but he had given the consent. No, consent is not going to justify it, because it is completely a separate or a specific offense. What is mentioned in section 29? The exceptions under 25, 26, 27. 25, sportsman. 26, surgeon, doctor's protection. 27, any act done on unsound mind or a child below 12 years of age with the consent of guardian. Means 25, 26, 27 is telling about if consent is there, then it is not an offense. But these exceptions 25, 26, 27 do not extend to acts which are offenses independently of any harm which it may cause, or intended to be caused, or known likely to be caused to the person giving the consent. So here, though consent is there, it will be an offense. The person will not be immune under 25, 26 or 27 only because consent is there. We'll take an example. Illegal abortions, miscarriage is taking place with the consent of the concerned woman or the guardian. The doctor is not exempted. He will be liable. He can't say here that the woman had given the consent, the concerned woman has given the consent, therefore I have done it. No, you should know it that whatever you are doing, that is completely a offense. It is a prohibitory act. Therefore, though she gives the consent or the guardians give the consent, it will be an offense. The doctor who is doing that illegal abortion with the consent of the woman will be punished, because miscarriage, illegal abortions are a separate offense, independent offense, as mentioned in section 29. Therefore, section 29 states that though consent is there, it will be an offense. Okay, now we are having Medical Termination of Pregnancy Act. Also, we are having Prenatal Diagnostic Technique Act, which provide for abortions which are called as legal abortions. There are certain conditions for the health of the woman, or because of the abnormal child who is going to take birth and all. If in those cases, or it is dangerous to continue the pregnancy for the life of the woman, then Medical Termination of Pregnancy Act and Prenatal Diagnostic Technique Act provide for abortions, and those are not an offense, those are legal abortions. But illegal abortions means the abortions which don't come under these two acts are illegal. If those are being done with the consent of the woman or the guardian, the doctor will be liable. Got it? That is section 29. Now the last section is section 30. Act done in good faith for the benefit of a person without the consent. See, till now from 25 we have seen about consent. 25, 26, 27 states that if consent is there, it is not an offense. And section 29 is telling that though consent is there, it will be an offense. Now section 30 is telling that though without consent, there is no consent, but it will not be an offense, because the act has been done in good faith for the benefit of the person. Though without the consent, it is not an offense. We'll take an example. Of a doctor itself. A patient is being brought in the hospital by some people. They are not their relatives. The concerned person has faced an accident. He is unconscious and he has been brought in the hospital. The doctor can't wait for the relatives to come. The concerned person who has faced the accident, he is unconscious, and the doctor has to take immediate operation on him. He can't wait for the consent. His ethics tells to save the life of the patient, and that will be saved only if he has been operated immediately. So what the doctor will take? The doctor will do, or the doctor will take the decision of doing operation without the consent. He will do his best to save the life of the patient without the consent, and here if the concerned person dies, the doctor is protected under section 30. Means here without the consent, though he does an act which causes anything, the doctor is protected, because he is doing the act for the benefit, he is doing the act in good faith, and therefore the doctor will not be liable. But now this exception under section 30 will not protect if the act is being done with intention of causing death, or it is an attempt of causing death, or it is doing anything likely to cause death, or voluntarily causes the death, voluntarily causing hurt, or attempting cause hurt, or any purpose other than preventing death or hurt. Means if all these things which I told you just now in the proviso, they are like, the person will be liable here, because it is not in good faith, because it is not for the benefit, because that has been done with the intention of causing death or attempting to cause death, doing anything which is going to likely to cause death, and doing anything voluntarily causing hurt or attempting to cause hurt. So section 30 is not going to protect the person in these circumstances. Leaving this, if a person does anything for the benefit, for the good faith, though without consent, he will be protected. Nothing is an offense. We'll just revise from 25 to 30. Section 25 to 30, they tell about the concept of consent or the position of consent in criminal law. Section 25 states a person about 18 years of age, if he has given a consent to take the risk, to take the harm, to suffer the harm, then the other person who causes the harm, he is doing it without the intention of causing death and all, then he will not be liable under section 25. Section 26 states nothing which is not intended to cause death of a person, if that is being done for the benefit, in good faith, and with the consent of the person, then nothing is an offense. This section 26 is protecting surgeon. Section 25, you can take an example of a sports person. Here the person should be above 18 years of age. Now 27. In 26, you can take an example. A patient comes to the doctor has given him every information about the operation. The patient has given the consent, he has signed the consent form, and he is being operated for any harm caused for the benefit, for good faith, the doctor is to be protected. Now section 27 states that with the consent of the guardian, if some act is being done on a child below 12 years of age or an unsound mind person, then that will not be an offense, because it again is been done for the benefit and in good faith. Next is section 28, which is just defining the word consent. Consent will be consent if it is not affected by fear of injury, misconception of fact, intoxicated person's consent is no consent, drunkard person's consent is no consent, unsound mind person's consent is no consent, and a consent given by a child below 12 years of age, it is also not a consent. Section 29 states that though there is a consent, it will become an offense, because that is an independent offense. No person can justify an illegal act, a lawful act, which is done by consent. Therefore, though consent is there, the person is liable in 29. Under 25, 26 and 27, the person is not liable. Nothing is an offense. 28 is defining the consent. 29 is telling though consent is there, the person is liable. It is an offense. Now 30 is telling that if an act is being done in good faith for the benefit, though it is done without the consent, it is not an offense. But this will not protect a person for intentionally causing death or attempt to death or voluntary causing hurt, or which is been done, which is going to likely to cause death of the person. Got it? This is the position of consent in law. Section 25 to section 30 of Bharatiya Nyaya Sanhita. Okay, bye bye. See you in the next video.